And before we call the next witness.
That was Victor Bain, a sporting goods store owner who was on the stand talking about his relationship with defendant Tex McIver, who is now an attorney sitting in the defendant's chair on charges that he murdered his wife. He says a gun went off accidentally. Here to help us analyze what's going on in the Tex McIver case, Daniel Goldman. He's a former prosecutor, current attorney. Welcome to Law and Crime.
Thank you very much. Thanks for having me.
So what do you make of this Tex McIver case? You've got a sophisticated client and a sophisticated victim. They had this financial relationship that was very, very hard to untangle. Hours of expert testimony.
I think that's generally speaking, and I'm speaking in platitudes to some degree, that's usually more of a problem for the prosecution. As a prosecutor, anytime you're getting into a lot of expert testimony, that's problematic. Usually you get into a battle of the experts, it favors the defense. And if you need to explain your case through experts, then you're running into some hurdles just to get the jury to understand it.
Yeah, I think we're going to go back to the Tex McIver courtroom in Atlanta, Georgia for some more live action.
What we're here about, and so don't be surprised if it is condensed and a little choppy. You'll be hearing the relevant portions of that conversation from April 28th of last year. Does this have an exhibit number that I can put on my unrevised exhibit list?
It does.
Okay, folks, what we're expecting to hear after we take a quick break here on the Law and Crime Network is an interview with a journalist that was done by the defendant. We're priming to hear that in open court. We're going to take a break. We'll be back in a moment here on Law and Crime Live on Crime and Investigation. Folks, welcome back. We have another witness on the stand in the Tex McIver trial out of Atlanta, Georgia. It's the case of an attorney now sitting in the defendant's chair on charges that he murdered his wife. A lot of people are saying this is a very tough case for the state to make out because by all accounts, the husband, the defendant, and the wife had a loving relationship, but they did have a pretty complicated financial arrangement. They were both married later in life. They were both very successful. They both at various points had a lot of money. The wife was loaning money to the husband. They owned property together. They had expensive jewelry. And there's been a lot of back and forth with expert witnesses in the Tex McIver case, as we have heard throughout the day. Let's listen into a little bit more of the testimony live from Atlanta, Georgia.
Goes to U.S. Enterprises.
Yes.
So now, Diane's estate still owes U.S. Enterprises $475,000.
Approximately. That's
Okay.
correct.
That gets satisfied. One of the ways it gets satisfied is the estate gives to U.S. Enterprises some billboards some property that Clay Management owned.
Yes, the estate satisfied, they chose to satisfy it that way, in that manner.
So, all right, just to make sure I've got this right. Diane's estate.
Well, Judge, I'm going to object. This is kind of the objection I've drawn a couple times, that we go back over the testimony we just heard again. So it looks like we're about to repeat exactly what Mr. Ricker just very clearly and plainly explained. Are we?
I'd like to write it down in visual form, like we've done with other witnesses on the chart, and then I'll be done.
Okay.
Diane's estate owed $975,000, correct? To U.S. Ultimately,
U.S. Enterprises filed a claim against the estate for that amount.
Okay.
Another in the lengthy process of reviewing questions from members of the jury in the Tex McIver case. So I've said this a million times before, we'll say it again. When jurors get to ask questions, they are subject to objection just the way any other question from opposing counsel would be. So when jurors ask questions, they're submitted on those little cards that you see the judge taking from the jury and walking over to the attorneys. The attorneys get to look through them. The members of the jury are usually told that, look, if a question is not ultimately asked, don't look into that. It just may be subject to an objection of some sort. And that's ultimately how the process rolls along. We have had expert witness after expert witness in this case, and we're expecting any moment to hear a media interview that the defendant himself did at some point, presumably when he was in jail. They had a little bit of technical trouble getting that thing up on the screens, and that's why we haven't heard it just yet in court. So they called this witness, and then hopefully they'll get the tech issue solved so that they can actually play the recording. Daniel Goldman is still here in the studio with me. Daniel, we were talking, this is an interesting process of jury questions. We don't see it in every state.
Absolutely. It's unusual, and it presents a very interesting perspective for the lawyers to understand a little bit about what the jury is thinking as the trial goes along. In federal cases, certainly, where juries are not allowed to ask any questions of witnesses or attorneys or anything of the sort, that you really have no idea. It's a big black box, and you have no idea what the jury is thinking at any moment. But when you get these questions, they may or may not be relevant and to the actual case, but you really get an interesting insight into what's going through the juror's mind. And I would imagine that both parties, both the state and the defendant, are adjusting their questioning based on where they think that the jury is focusing on.
Oh, for sure. Let's listen back in. They're probably just very close to actually asking the questions.
By Mr. Harrell of the 975.
No.
Okay. The approximately $500,000 for billboards / property. What do you know the origins of the funds that covered the remainder, not covered by the insurance policy, of the debt of the estate?
The only thing I know is that they were owned by Clay Management. I'm not sure where the funds came from, were Diane's funds, but Diane was she was the sole owner of Clay Management, as we've talked about before.
Do you know who had control of Clay Management after Ms. McIver's death? Because as I understand it, all this happened after she passed.
It did. You're correct in that it took place after she passed. I believe, to my recollection, Clay Management would have gone into being a part of the estate.
Okay. Any follow-up, Mr. Rupp?
I think earlier you said $500,000 of the $1 million got applied to the $975,000 debt. Do I have that right?
Yes. Mm-hmm.
The other $500,000 from the $1 million insurance policy went where?
To Mr. Harrell.
Okay, went to Mr. Harrell as 50% owner of DRS.
Correct.
Okay.
Ms. Clark, hold on.
Mr. Rickert, you said that Clay Management became part of Diane's estate, right?
To my recollection, yes.
After she died, it became part of her estate, right?
Yes.
And whatever assets and liabilities that Clay Management had, her executor would have to be responsible for those, correct? The executor of the estate.
You phrase that again. It was a...
Let me ask a better question.
This witness was general counsel to one of the companies that Diane was managing and also acted as her personal attorney on her will. He's been a critical witness. We're going to go back to that case live in a moment when we return here on the Law and Crime Network Live.
At some point in time, you emailed Leon about, I guess, your passport and your glasses.
Correct.
Pardon?
Correct.
All right. And when was this?
I don't recall.
Was it during the period of time that you were separated from Leon?
Yes, sir. It was after I went back into my home and realized my belongings were gone.
Okay. And he found those, did he not, and returned them to you?
I believe he had taken them out of the location they were, so he had them on his person.
My question is, relative to the passport and glasses, he found them and returned them to you, correct?
I would not say he found them.
He returned them to you, did he not?
I asked his sister or brother to return them to me, so he had no contact with me or my work.
All right. But in any event, you got your glasses and passport based on his actions about getting them to you through his relatives?
Yes.
Okay.
Okay, folks, we were reviewing testimony there in the Leon Jacob case. That witness on the stand was the ex-girlfriend that he was accused and ultimately convicted of hiring a hitman to try to take out. The hitman turned out to be an undercover cop. We're in the midst of taking a listen to the punishment phase of that case. The defendant already convicted, the jury hearing additional evidence to decide the punishment. But we're seeing a really interesting setup in the Tex McIver courtroom. Prosecutors just brought in weapon after weapon after weapon and set them up on a table right in front of the jury box. These were, it looked at the end like a mountain of guns. So clearly, we're interested to see where this is going to go. Some of them had tags with the defendant's name on them. We know from a gun store owner that he was a frequent customer. Of course, it is legal to own weapons in this denomination. And what's interesting here is that the defense, right at the tail end of it, was snapping pictures of the display. If I were to guess, Daniel Goldman, that's probably because they want to preserve this for the record.
Absolutely, and my guess is they objected to the state showing all of these guns because it's not in dispute that Tex McIver shot his wife. There's no issue here as to whether he, owned the gun or had the gun that was relevant. And so by showing all of the guns that he owns, there's a real argument that this is overly prejudicial to him. It's for show that is not relevant to the actual issues at trial.
Yeah, and right there we saw the defense attorney snapping pictures with his phone of this pile of guns set up by prosecutors. And I think you hit the nail on the head. Is it going to be more prejudicial or more probative as to whether or not this one gun went off and hit the victim? We're taking a break right now. We'll be back with more live testimony here on Law and Crime Live.
It's going to be a Luger. Serial number is going to be actually.
This is the criminal investigator who recovered 44 weapons owned by the defendant, and he's now going through them point by point, reading serial numbers, cataloging them on the record. Daniel Goldman, you are here analyzing this with us. We know that the defense objected to this display of all these weapons. So what? The defendant owned a lot of guns. That's legal in this country. He had a shooting range at his ranch. People testified that he had these weapons. The state says they need to show all these off to the jury to prove the defendant's knowledge of guns. But the defense was saying, hey, look, this isn't probative as to whether or not the one gun that was in his possession the night that his wife died went off. Did it go off accidentally or was it murder? What do you think?
Well, I think this is a little bit of a sideshow, frankly, and I think that it is an effort by the prosecution to kind of muddy up the defendant a little bit by showing that he has all these guns, he's facile with guns, and somehow have the jury draw an inference that, therefore, because he owns a lot of guns and is capable of using them, that he therefore intended to use them. But that's not a logical leap, and the problem is there's a gap there that needs to be connected because, as you point out, Aaron, there is no dispute here that he shot the gun. This is one of those unusual cases where the facts are really not in dispute about what occurred. It's all about the motive. What was his intent? Was it an accident, or did he mean to do it? And as we were talking about earlier, when you have a lot of experts getting into financial data and financial records, that's not a particularly compelling motive case.
Yeah, this is certainly more visual. I mean, we're watching this live right now. Look at the pile of guns, and the prosecution is milking this for all it's worth. They're having this witness, the criminal investigator, read the serial numbers, handle every single one of them, it looks like, show them to the jury. Look, Daniel, you're a former federal prosecutor. You were in the prosecutor's chair. I'll just ask this point blank, and forgive me, is this evidence of a stretch, or is this going to make the point?
I think at this point they're trying to cobble together everything that they can and bits and pieces to be able to pull something together that this was someone who had facility with guns, could easily do it. It wouldn't be out of the question or unusual for him to shoot a gun, and it wouldn't be unusual for him to think, oh, if I'm going to do this, I will shoot a gun. There are a lot of holes, though, that still need to be filled before you get to an intentional murder.
I just got a note from senior trial producer Kathy Russin, who is helping us pay attention to what's going on in court. They're taking the guns out of the courtroom now, so now that the jury has seen them, the investigator will continue to testify. So this is a lot of work, bringing these into court, showing a number of them off, and then carting them right back out again. This is a lot.
But it's a lot more interesting than financial records.
Well, that's true. I will admit that.
From the jury's perspective, I'm sure they're happy to see this, as it's a little bit more activity than what they've been used to in this trial.
They suddenly woke up this afternoon, perhaps. I mean, sometimes you have to stagger these things to keep the jury engaged. But again, I mean, it goes back to the point, like, look, just because this guy had a lot of guns, where's the state going to go with this? Are they going to say, okay, this guy had a lot of guns. He knew how the trigger worked on every single one of the guns. He knew just how much pressure needed to be applied to the trigger of a rifle versus a shotgun versus a revolver versus a pistol, you know, something like that. I'm curious to see where they're going to go with this, but it looks like questioning is going to resume, so let's listen back in live.
From the investigator, Mr. Hyde, belong to the defendant, and how many belong to Diane McIver?
I do not know.
And can you tell the jury, as far as your connection to the investigation or the presentation of evidence in this case, did you do anything else?
No, just obtained evidence.
Okay. All right. Thank you. That's all my questions.
Mr. Harvey, questions for investigator's office?
Good afternoon, sir.
You good?
Yes, sir.
All right, good.
We are live in the trial of Tex McIver, an attorney facing murder charges related to the death of his CEO wife. Cross-examination of an investigator just beginning. We will still monitor it, but we need to take a break. We'll be back with more live testimony in just a moment here on Law and Crime Live. Perfect time to come back, folks. The last witness is off the stand, and the judge told the jurors that they're about to hear another interview recording of the defendant. Now, we heard one earlier where the defendant said that his net worth was 2.5 times his wife's net worth. The wife, the victim, Tex McIver, the defendant. You know, the expert said that those numbers just don't add up, that the wife was worth a lot more than the husband, that the husband had debts to the wife, had other financial wranglings that just don't make out the case that he was worth 2.5 times what she was. So I'm curious to see what this next clip is going to say. Possibly could it relate to the 44 weapons prosecutors just brought into this Georgia courtroom and basically paraded in front of the jury? Could that be the subject matter of this clip? It looks like they're getting ready to play it in court, so let's listen.
Got her by shooting her.
Guns are not my thing. Or some theories that
this is being done because of my need for her money and so on. It's just not the case. As it turns out, she was very, very successful in her own right, coming the way she did, but I was more.
That's all of 486. Okay. Ladies and gentlemen, we are done for Wednesday. Tomorrow's Thursday. That's how the weeks work. I have a meeting that has been rescheduled a bunch of times because this trial has kept going, and I have to go to it tomorrow morning because I host it. It is just 5 floors up, so I'll be here, but it's going to be closer to 9:30. You're welcome to get here at the time you normally do and have the freshmen get together, as long as you're not talking about the case. But know that we won't be asking you to come out here till around 9:30. So you won't be late if you come in at 9:15, because we won't get started before 9:15. And there'll be no fussing at anyone if they come in at 9:15. We'll try to get started as close to 9:30 as possible. We've got a particular time we need to break for lunch. And then we'll go tomorrow so the lawyers can plan a 5 or a 6. It's a 6. Okay. You guys will work through that, but I'm aiming for 6, especially since we're not starting until 9:30. But you talk amongst yourselves. You can let us know in the morning, but we'll make sure the state has enough folks to get us through 6. And if we end a little early, they will have had enough folks to get us through 6 o'clock. Thank you for your time. Enjoy your evening. We'll see you around 9:30 tomorrow morning.
The end of the day in the Tex McIver case in Atlanta, Georgia, we saw guns brought into the courtroom. We saw 2 clips from competing television stations in the Atlanta area, ultimately with the defendant saying that his wife was very successful, but he was even more successful. So, Daniel, we've got the guns, we've got these clips, we've got experts who disagree with the defendant's stated version of his own financial affairs. Can we link the two? Are they unrelated? Why did we see the clips at separate points? You're a former prosecutor. Can you make sense of this?
Well, I don't think they're related. I think the reason you see clips at different times is just to break up the witnesses a little bit, break up some of the rhythm of the trial, and also just timing. It's the end of the day. That was a short clip. Let's play that. And then there's also some strategy where you want the jury to leave on a note that's good for the prosecution. And since they've been setting up all of these financial issues that he had and the financial motive, to end the day by saying, I had more money than she did, which means, you know, that wouldn't be my motive. That's if they can prove, as they're trying to do, that that's not the case, that's a false exculpatory, and that can be somewhat powerful evidence to show if he's lying about this, and the reason he's lying about this is that this was actually his motive, and he's trying to cover up his motive for killing her, which is what their whole case is really premised on.
The full clip from what I'm getting notes right now said, guns are not my thing. There's a theory that this is being done because of my need for her money. It's not the case. It turns out she was very successful in her own right, but I was more. That guns are not my thing. That's apparently what the defendant said in the very beginning of that. Maybe it's just that we couldn't hear it in the studio, but look.
Well, that makes more sense.
That makes more sense. We've got 44 weapons. It kind of looks like guns were somebody's thing, and they've got tags on them that say that they were Texas guns.
The beauty of trial is things come in, as we used to always say in federal court in the Southern District of New York here, bits and pieces. And so when we were watching all these guns come in, we said, well, that seems incredibly prejudicial when there is not an issue here as to whether or not he shot his wife. But now that makes a little bit more sense. If he's saying guns are not my thing, and then you parade in 44 guns to show, well, guns really are his thing, what they're doing is they're slowly and steadily undermining his credibility, and that's bolstering their evidence of a motive to kill her.
You know, doesn't necessarily mean that he killed her with intent, because, you know, look, maybe maybe the guy's being shifty. Maybe he's changing his story. We've heard that before as to some of what he was saying in the emergency room after he brought his wife in with the gunshot wound, that he gave nurses a couple of different versions of how this shooting happened. Does that necessarily mean that he was meaning to do it, or is he just the kind of guy who's trying to spin things because he's used to being in control of the narrative? And look, I realize it looks bad either way, but it doesn't necessarily make somebody a murderer.
Well, the way that the argument plays out is, if this were truly an accident, he would have no reason to lie about anything. And he would not be trying to cover up anything about himself or what happened. And that's why the evidence about him trying to tell the driver, her best friend, to go home, or to tell them that she just came and that she wasn't driving the car, and that's why this evidence that guns aren't my thing and I'm more wealthy than her, that all sets up in favor of the state to be able to say, he's trying to say it was an accidental murder, but if it was an accidental murder, what's he trying to cover up? Why wouldn't he just be honest about that and say, look, I feel horrible, this is terrible, but this happened? Yeah, I own 44 guns. Absolutely, I had loans from her. She made more money than I did. There's no reason for him to hide anything if it were truly an accident. And the fact that he's trying to hide several things, including the financial aspect, including the guns, including the driver, it now starts to paint a picture of this guy's trying to hide something. I still think there's a big leap to get to intentional murder, but that's the inference that the state can draw.
At a minimum, this will show some degree of recklessness, perhaps. I mean, you should know that if you're going to have a gun out and it's pointed in some general direction towards your wife, if you have this many weapons, then surely you should know how to handle them safely. A lot of people are making that argument, too.
Yeah, and I think that really falls in the very narrow window between an accidental shooting and an intentional shooting. And maybe they would find in sort of the jury might find in a compromise situation, let's do recklessness because it's between accident and intent. But I think that's probably the third most likely outcome here.
Interesting analysis. Daniel Goldman, former prosecutor, current attorney, great to have you here on Law and Crime.
My pleasure. Thanks for having me.
We're going to continue this analysis. Let's look back at one of the key witnesses in this case, Danny Jo Carter. She was the friend of both of the McIvers, both the defendant and the victim, who was at the wheel. She was driving the car when the gun went off in the back seat and the bullet went through the wife in the front seat. Here's some of what she had to say about Tex McIver and his weapons.
Can you explain to the jurors how is it that you can recognize this particular weapon?
Well, I'd seen it in the console before.
Okay.
And
okay, go ahead.
It wasn't in a plastic bag.